Good afternoon. I'd like to welcome everyone on behalf of the Most Worshipful Prince Howard Grand Lodge of Louisiana, Dr. A. Ralph Slaughter presiding as Grand Master, and on behalf of the 7th Masonic District, where the Honorable Sharon Papillon presides as our District Deputy Grand Master. I'd like to welcome you to the 14th Judicial Judges Candidates Debate, and without further ado, now let's move into this. We're going to start with the Pledge of Allegiance. If I can have everyone rise with me. We're going to do a short prayer, and then I'll allow the candidates to introduce themselves and make a short opening statement. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
While you're yet standing, let us pray. Most gracious and everlasting Father, we come this afternoon thanking you for all your good gifts and graces. We come this evening asking that you bless this nation, this great nation of which we are citizens. We ask that you bless our elected officials and their families. Give them the right mind to serve the constituencies they represent. Now, Father, we ask that you bless this event. Bless each of these candidates. Let each be of a mind to serve the people of this district. We ask that you just be with us all. Bless us and keep us in the mighty name of Jesus. Now that we have refreshments, we come asking, Father, that you bless the food which was prepared for the nourishment of our bodies. We ask that you just be in our midst this evening. Bless us and keep us in the mighty name of Jesus. We ask these in all things. Amen.
Amen. Thank you. I'd like to give each candidate, starting at my left, Mr. Ned, the opportunity to introduce yourself, sir, and make a short opening statement.
Sure. Thank you. It's an honor and privilege to be here today. My name is Michael Ned. I'm sorry. It's an honor and privilege to be here today. My name is Michael Ned. I'm a native of Lake Charles. Maybe you see me around. I have two little girls, Aliana and Paige. Maybe you see me around in the mall, Books and Maid, Walmart. I'm not much of a politician, but I know I like people. I want to help people, and I care about people. Things I want to do is protect the community from violent offenders, protect our kids from sexual offenders, and protect our kids from drugs that will hurt or harm. I want to treat them fair and equal, with integrity and respect. I want to help integrate nonviolent youth offenders back into society and give an opportunity to defer sentences for nonviolent citizens in order to keep their record from being blemished and succeed. I choose the path of rehabilitation in order to help our citizens become taxpayers instead of tax burdens. I believe my compassion, strong work ethic, involvement in the community, life experiences is what make me qualified to be judge. Thank you very much.
Thank you, sir. Thank you very much. Mr. Keith.
Mr. Moderator, ladies and gentlemen, my name is Derrick. Very honored and privileged to be here. Opportunity for us to understand that history is calling upon us to do something that is outside of the proverbial box, outside of those things that have been holding us back from moving forward and being progressive. As I see Mike has read my data very well. He understands what my campaign is about. In fact, he's quoting from me when he says that he wants to see taxpayers rather than a tax burden. That's on all of my literature, that's on my Facebook, that's on my website, that's everywhere, because these are things that I've done that I value very, very, very close to my heart. It's no different what I'm asking to do as a judge than what I've asked to do as a lawyer, to advocate for what's right, for what's fair, to fight for folks, for people, everyday individuals who count on us to be strong, not weak. If you're voting for the status quo, then you need to vote for one of these other two individuals who are running against me. I'm not a status quo individual. I am committed to being strong for this community. I'm committed to bringing new ideas. Mike brought up one of them. That is turning folks into taxpayers, not tax burdens. So you're gonna hear some things today about some programs I have. Innovative ideas that you haven't heard anywhere else. You're gonna hear about my free to work program. You're gonna hear about my incentivizing good behavior program, which allows people to be certified and to give them an opportunity to be released early for nonviolent offenders and for folks who have already spent substantial time in jail as well, to certify people to work so that they can be viable members of society. That's Derrick kid. That's what I'm about. That's what I'm for. That's what I'm always going to stand for. And we're going to hear today the distinction, great distinction between my two colleagues who are good friends of mine who just have a different plan for the future than I do. And I'm going to make sure that distinction is very strong, very clear, very concise, something that the public can count on. Thank you.
Thank you. Ms. Wilson.
My name is Sharon Wilson. I'm an attorney. I've been practicing law in Lake Charles for 22 years. The first thing that I want to do is thank the Mason brothers for having this forum. I really appreciate it. I wish we'd have had more of an attendance because this race is very, very important. It's very important that you know who each of us are, what we bring to the table, and what we will do to help advance the direction of the court, because that's what this is about, advancing the direction of the court. I am a 47-year-old mother of two. I've been married for 17 years and lived in this community for the last 22 years. I'm a member of the Mount Calvary Baptist Church. Very proud to do that, very proud to serve as a Sunday school teacher, and very proud to serve in the choir and in any ministry where I'm asked to help in church. I'm telling you that because I think, and I've said it on the campaign trail, it's very important that you know what you're getting. What you're getting in me as a Christian. And the reason I say that is because it is about a relationship. And I live my life because I live, move, and have my being in Him with this relationship. This relationship influences everything that I do. The law is based on common sense reasoning. It's also based on the law, the original law that Moses handed down. I've been doing this for a long time. What I'm going to bring to this seat is fairness. It's important. Yes, everybody wants to be fair. We may not always know how to get there. Discernment helps in trying to establish what is right when someone's appearing before you. One of the things that I've said in church, and I'm not ashamed to say here or at the courthouse, is that the reason I say that I'm a Christian is because I got judged once. And I got judged by the Almighty. And He judged me not for the wretch that I was, but for who I could be. A judge needs to have the discernment to be able to see who people can be, not the circumstance that brought them into the system. I ask for your prayers, your support, and your vote. Thank you.
Thank you. And thank all of you candidates for coming out today. I'd like to thank our sponsors for their support. Thank the members of the community for their attendance. And I believe it's very important that I explain exactly what we're here about today. So if I may, I'd like to point out that the landmark case of Ronald Chisholm versus Charles R. Romer, governor of Louisiana, led to a consent decree in 1992 that created minority judicial districts across the state of Louisiana. The way the voting districts were designed to dilute the minority vote, it was virtually impossible for an African American to be elected as judge. The consent decree led to the creation of two minority districts in Calcasieu Parish. Judge Alcee Gray and Judge Wilford Carter, who were both Prince Hall Masons, I might add, were the first African American judges elected to these two divisions. Judge Gray was replaced by Judge Ronald Ware, and now we have the three candidates before us running to replace Judge Carter in Division F. Now, Judge Carter was not only the most senior judge, he was also the longest sitting African American judge of the 14th Judicial District Court. He's a U.S. Army veteran, so he has served the people of this nation. But many may not know he was also a mail carrier. so he has served and is very well acquainted with the people of the community. He has served on the city council representing districts A and B, as well as serving as the city council's president. He then went on to serve as a Louisiana state representative. So Judge Carter has known for quite some time what it means to stand for the people of this community. That's very important. Throughout his tenure as judge, Judge Carter always understood the importance of being one of the first minority judges to serve under the consent decree. He understood that the purpose of the minority districts that were formed was to provide minorities access to the court. Judge Carter was no doubt the most accessible judge ever to serve in Calcasieu Parish. And when I say accessibility, I don't mean that you just had his cell phone number, but you had his attention. He recognized that our community had been systematically denied the same access, compassion, and understanding that is standard in the majority community. Judge Carter also understood that the intelligence and competence he showed on the bench would create opportunities for young African American lawyers that came behind him, like yourselves here today. But Judge Carter never for a moment let his desire to be accepted by his fellow judges keep him from standing up for what was right. He understood that it was more important to be respected by them than it was to be liked. Judge Carter is indeed a tough act to follow. And whoever is elected will have some pretty big shoes to fill. I'd like to ask you, Mr. Ned, if you would please explain how the consent decree creating Division F affected your career as a lawyer, and why do you believe it is important to have minority districts?
Very good question. For me, it was especially spectacular as a law student being employed by the 14th Judicial District Court to work for the judges. I had the opportunity to work for Judge Allison, the late Honorable Allison J. Gray. It was spectacular to me to have someone there that looked like me, to have beliefs like me, and ideologies like me, to go in front of. As a public defender, it was an honor to serve in front of both judges. I was in Division F for quite a long time, representing civil liberties as a public defender, criminal staff attorney. And it was important to have someone that I know would listen to me and hear my voice, someone that would have a reflection of the community, the minority community, someone to represent a strong and resonate a stronger voice for our community. I think that it was a blessing to have Judge Gray and Judge Carter on the bench to make decisions that affected our community, that someone that set reasonable bonds, someone that be available and accessible, someone you can rely on to be there. We need that phone call in the middle of the night. So I think it was a blessing for our community to have two distinguishing judges on the bench. Thank you.
Thank you. Mr. Keith, if you would, please explain how the consent decree creating Division F affected your career as a lawyer, and why do you believe it is important to have minority districts?
The consent decree is important because it marks a place in history wherein there was a dark place in history where we didn't have a voice, we didn't have strength, we didn't have somebody who represented the character of our children. We had people who would go before judges that were not similar to them, who were not familiar with the way they came up. Didn't have certain sensibilities, but just not bad people, just didn't have that experience. So the consent decree opened up a door that all three of us have been able to walk into, a door that says we have strength as a people because we have not only a spot on the bench, but a voice, a mind, a heart that thinks about us on the bench. I think about Judge Carter. I think about Judge Carter probably before everybody else started calling him about bonds. Before people started talking about, he's looking out for the community. I think of him as an inspiring young guy, just like me, who just said, I just want to do something great for people. And I'm going to do that because it's consistent with what I've done as a mailman, as all the other ways that he's helped the community. That's what I've done. That's why it's important, because you bring your life experience to bear. That's why Judge Carter is and was who he was, because he brought his life experience. That's what I'm bringing. That inspiring eye of the tiger. But it marks history. History for minorities in a district where they need history. Our children look to us, and I said this at the last forum, they look to us to say what they can do, what they can become. But for Judge Carter, when he was young, as I explained, history was not something in the past. History was now. And I want you to know that in 1992, for Judge Carter, for Judge Thibodeau, for Judge Gray, history was now. For Jonah in the belly of the whale, Daniel in the lion's den, Shadrach, Meshach, and Abednego. Yeah, I'm a Christian too. But I let my light so shine before men that they may see my good works and glorify God who is in heaven. So I tell you, I remember what history is. History is now us looking back on what happened for them in the right now, in the present. And in the present, Judge Carter was willing to take the plunge that I'm taking now. And that's what it means, giving us an opportunity to step out and be strong for our community. Thank you.
Thank you. Mrs. Wilson.
First thing I want to do is thank you for calling me a young lawyer. I worked hard to look young, so I appreciate that. It's very much a compliment. The way that it has affected me is when I first started practicing law, Judge Thibodeau, Judge Carter, and Judge Gray were practicing attorneys. And even when I was in law school, Judge Thibodeau came to LSU because there were several people from Lake Charles at LSU, and he started mentoring us then. And when I was recruited to come out here and accepted the job at the DA's office, Judge Thibodeau, Judge Carter, and Judge Gray were very important in helping me with my legal career and practicing. And then once they became judges, it was a different world before they were judges, in the sense that you had an all-white panel that you'd go to court and appear before. And I remember being that 25-year-old lawyer, nervous, and getting that encouragement from Wilfred Carter. You got it. Good argument, lawyer. Just stay strong, because you didn't feel the camaraderie coming from that bench. When that bench changed in '92, and we had those two judges there, you had judges who had like experiences to your experience, and they were very helpful in helping us navigate that system, because they had the battle scars of dealing with racism within the legal system, and they've opened some incredible doors for us. For my clients, it means that I have a judge who understands certain things, understands that a client is not being disrespectful when he says a certain thing. It is a cultural difference. So it's very important. It's very important that everybody have a seat at the table in the courthouse, and that people feel like there are judges who have common experiences. So I am grateful for the consent decree.
Thank you very much. Okay. Mr. Key, Division F is a standalone division that makes up 1/9 of the 14th Judicial District Court. Oftentimes, there are votes that act to limit the types of cases that the minority division can hear. Examples include limiting a division to only hear domestic cases, or limiting which judges can hear drug court cases and DWI court cases. Do you think there should be internal votes that limit Division F's autonomy?
Absolutely not. I think that people elect us, our constituency, they elect us so that we can represent them all types of cases. There's people who go to the polls today and go to the polls over the next couple of weeks, and they will never come before a criminal court. They'll have family law issues, they'll have contractual issues, they will have all types of disputes, employment issues. And the important thing is that we don't water down our representation at any level. I think that the judge in Division F should be able to hear all types of cases. And that's something I'm gonna work towards when I become judge, God willing. I'm gonna work towards getting more visibility in other types of matters. And it's important because I've said before, I grew up in a house with 22 people, and you better believe it was every type of dispute that you can find under the sun. And the disputes were not all criminal. The disputes were not all domestic. There were different types of disputes, and our community has all of these disputes. My house with 22 people, and it was a microcosm of what goes on in our community. And we have to make sure that we have representation across the board. I would obviously favor having Division F here, family law cases and all types of matters, domestic, and not to exclude juvenile matters, because our children are going in that court every day. As you know, just last week there was an allegation that a 12-year-old shot a 15-year-old. Our children got to go through that system too. They have to, and it's for us to make sure that we make ourselves 100% accessible across the board.
Thank you. Mrs. Wilson?
I'm sorry, could you repeat the question?
Yes, ma'am. Division F is a standalone division that makes up 1/9 of the 14th Judicial District Court. Oftentimes, there are votes that act to limit the types of cases that the minority division can hear. Examples include limiting a division to only hear domestic cases, or limiting which judges can hear drug court cases and DWI court cases. Do you think there should be internal votes that limit Division F's autonomy?
Well, you cannot have an internal vote that would limit Division F's autonomy because it's governed by law what Division F can and cannot hear. If that were to happen, I think you'd have to do the same thing that Judge Carter did, which is to stand up to the other judges, file suit when necessary, which is what he did, litigate the issue. As it relates to hearing family and juvenile court matters, it is imperative, in my opinion, that Division F never be a family and juvenile court seat exclusively. The reason being is there needs to be at least 2 minority voices in criminal court. Because in criminal court, you're talking about people being accused of life sentence crimes, and you're talking about people being charged with, in this area, we have a high charging rate out of the district attorney's office for violent crimes. You do not need to lose a minority voice in that court, so I would never be for that happening. If the judges were to vote to have that happen, I would fight that happening by any means that's necessary and legal. And I do the same thing that Judge Carter has done in the past. That's it. Thank you.
Thank you. Mr. Ned?
I think that it's imperative that Division F represent a broad spectrum of the community as far as civil and criminal cases. The whole reason for the consent decree is to make sure that we have a voice, and have someone resonate a strong voice, to have someone to go in front of that have ideas reflective of our values, our morals, and our ideologies. It was an honor to go in front of an African American judge, to have someone that looked like me, think like me, have values and beliefs like me. Someone to hear my voice and not ignore it. I think that as a practitioner, it was important to have representation from Division F and Division H to go in front of a judge who's going to give my client a chance, to give my personal interest of clients a chance to be adequately compensated, to give my client a chance to bond out, to be a productive citizen. We can't afford for this division to be diluted. And absolutely, I will contest it being broad spectrum of people in the community.
Thank you, thank you. Mrs. Wilson, when you read the American Press, our local newspaper, you see wide ranges of bonds set for similar charges. The bonds, and what will be your bond setting philosophy?
Bond should not be a punishment. When someone's arrested, that's only an accusation, okay? It only takes probable cause to arrest someone. To convict someone, they have to be proven guilty beyond a reasonable doubt. Bond should be set. The only thing that bond is designed to do is to make sure that someone appears in court. That's it. And my practice is going to be to follow the law. I believe that bonds should be reasonable and they should be commensurate with a person's ability to give bond. I've said this on the campaign trail. It is amazing to me what's going on in Calcasieu Parish. What's going on in Calcasieu Parish is that we have excessive bonds, and there's no other way to put it. I've argued in court to get bond reductions for my clients, and I stood up and said to judges, this is an excessive bond, because it is. We don't have an influx of millionaires, and if we do, I don't know where they are. But if you pick up the American Press, as you just stated, you're going to find $1 million bonds routinely set in this parish. I'm not doing that, unless it's a millionaire. If he's a millionaire, I'm still not give him $1 million bond, but if he's a millionaire, he's going to have a bond that's commensurate with his income. If I am earning a minimum wage living, and I am accused of a violent crime, if my bond is set at $10,000 and I'm earning a minimum wage living, that's the same as if I set it at $1 million. Because I can't afford it, but it still speaks to the seriousness of the crime. You have to follow the factors in the Code of Criminal Procedure when setting a bond, and I will do that. But I'm going to set reasonable bonds. I'm going to be accessible, just as Judge Carter is, to setting reasonable bonds. If you gotta get to work and you got arrested, you don't need me to say, well, let me go figure out what's going on. If you've gotten arrested for a relatively minor felony or misdemeanor, a bond needs to be set immediately, because you can bond out of jail and get to work. And I'm not going to interfere with people's ability for livelihoods simply because an allegation has been brought against them. It is an allegation. A bond needs to be set appropriately. Thank you.
Thank you. Mr. Ned?
Thank you. There's a serious need for conformity in the setting of bonds in the 14th Judicial District Court. The factors I would consider, of course, would be the evidence, the nature of the crime, whether or not the defendant is a flight risk, community ties, his financial status, and the likelihood that he will reoffend. I think that it's important that, and detrimental, that we do not have innocent people go to jail and be detained no longer than necessary. We understand people need their jobs, they need to work, they have families, and we can't have people just detained on mere allegations. Apart from those factors, the nature of the crime, flight risk, the danger he poses to society, financial status, community ties, I would think a judge would need to use common sense. And that's what's been lacking, I think, a lot in 14th District Court. Bonds are not meant to punish, they're not merely meant to detain, but they're only meant to ensure that the defendant is present at trial. Thank you.
Thank you. Mr. Keith?
Code of Criminal Procedure lays out very easily what a bond should consider, what a person who's setting a bond should consider. But the purpose is, and you've asked the question, what is the purpose? The purpose is to assure a person is going to come to trial, come to court, appear, have an opportunity to defend themselves, and have an opportunity to prove beyond a reasonable doubt that they actually not guilty of the crime. And that's what's important to me. But I hear some things, and I kind of hear things doubly coming from my opponents, and I said I was going to set myself apart by showing the distinction between me and my colleagues. One of my colleagues says, I'm going to follow the law. Well, are we suggesting that the other judges will set $1 million bonds and not following the law? No, they're going down, check one, check two, $3 million, see you later, see you at court. That's not following the law, it's not the only linchpin. If we follow the law, there was a time in this country, a very ugly time in this country, where women wouldn't have a right to speak without a man saying, that black people were not citizens, that under the Constitution, we weren't originally anything other than property. If we followed the law, we'd still be in that situation. That is not the purpose of the judiciary. The purpose of the judiciary is to interpret the law. And when you rightfully interpret the law, you get people, good lawyers who happen to be a woman, who happens to be running for judge, good lawyers who happen to be men or black, who happen to now be citizens, because we didn't take the law at its face value and say, hey, it said bonds astronomically. Hey, you can treat certain people differently than other folks. We're all citizens. We deserve to be treated with dignity. Last point, my colleague said she's argued for bonds to be reduced. She didn't mention the other 17 years she worked for the district attorney's office. Didn't mention that I argued for bonds to be increased. That's important. That is all of the information. That's not a small portion of it. So I suggest that we always think about our people, think about the situation, facts, and circumstances, and make sure the bond is consistent.
Thank you. Mr. Ned,
Yes.
what types of law have you practiced, and how has that prepared you to be an effective judge?
Sure. I guess I can start as a judicial law clerk for the judges, and I actually did legal research and wrote decisions and handled jury charges, applications for relief filed by defendants. After judicial law clerk, I went to the Third Circuit Court of Appeal as a criminal staff attorney. I handled writ applications and appeals, wrote decisions on a different level. On a trial level, it's beyond a reasonable doubt. You dealt with some different standards, probable cause, preponderance of evidence. On a Third Circuit Court level, we used the Jackson rule, and that determined the evidence in a light favorable to a defendant. So I have trial court experience and appellate court experience. Afterwards, I was employed as Assistant Attorney General for the state of Louisiana, handling complex litigation for the state of Louisiana and workers' compensation. Afterwards, I was employed as a public defender, handling misdemeanors and city court issues. I was later employed as a felony staff attorney and handling serious cases, aggravated rape, murder, burglary, distribution of cocaine, and etc. Later, as Michael P. Nair, attorney at law, I handled complex litigation, class action tort litigation, where we had settlements ranging from $64.5 million to $5.3 million, to $5 million and $1 million. And these were all against big companies and insurance companies that traded profit over the safety of our community. So I have a myriad of experience, a diversified portfolio, which makes me qualified to be a judge. Thank you.
Thank you. Mr. Keith.
Practice law in 2 states. Only candidate who seems to be marked as the inexperienced candidate. Only one bar in 2 states to practice law, which means I know more substantive law, or I have demonstrated knowledge of more substantive law than either of my 2 colleagues. But the practice has been civil, criminal, and administrative. When I was in Chicago, there was a big issue involving folks foreclosing on people's property who had taken advantage of these people. Represented 75 clients on foreclosure matters to help them save their houses. Didn't lose one because I felt like I needed to fight. As a criminal defense lawyer, both as a public defender and as a private lawyer, I fought for my clients in family law matters, employment matters, Social Security disability in 2 states, personal injury matters, civil rights matters, one of which I was involved with in Chicago that I took to the United States Supreme Court along with my firm. And also profiling cases where officers have violated the rights of citizens based on the fact that they're driving a rental car across the border and happen to be black. I have a problem with that. And that's why I've handled the type of cases I've handled. Now, as I told you, I've handled cases in the U.S. and Louisiana Supreme Court and district courts here in Illinois and in North Louisiana, 12 parishes here, 3 counties. I tell you that I've always had one goal: advocate hard for my client. Don't ask me, ask my clients. Ask the people whose lives Mr. Ned has affected. Ask the people whose lives Ms. Wilson has affected, and you'll find out that folks are well pleased. Last point, those people that I saw in Macmillan Park the other night came to me and said, Mr. Key, I really appreciate all the things that you've done for me. Because of you, I can work, pay my child support. I can do things that other people said I couldn't do. When I see you on that poster, it gives me hope. So I've handled all of those cases in a way that has been pleasing to my clients, and I think it's been pleasing to God because I've done it with all of my heart. Thank you.
Thank you. Mrs. Wilson.
There's a lot that I've done in my 22 years that has totally equipped me, and God's allowed me to have those experiences to be ready to handle this position. I want to address something that was just said. I was a prosecutor for 17 years, and I am honored that the Lord allowed me to have that job. Mr. Key was never an attorney in this parish when I practiced at the district attorney's office. I have never, in the years that I practiced in the district attorney's office here, nor in Allen Parish, went to court and asked that someone's bond be increased. I've never done that. I've asked that their bond be maintained or it not be reduced because that is the nature of a prosecutor. I did not do what he said. What I have done when I was a prosecutor is seek justice. And what I have done is been a voice for people who have been murdered, because those are the kinds of cases that I handle, and people who've been raped. And I am not ashamed of anything that I've done because my job was to seek justice. I became a Christian when I was 5 years old. I have never, ever in my life, ever abused someone or wronged someone maliciously. I've never done that. I have been a voice for people who did not have a voice. And I am proud that God gave me the ability to be that voice. Now, what have I done? I've been a prosecutor. I have said on the campaign trail that the reason that I am proud is because people had to die so that black people could work in the office of the district attorney. Right. There were years that we were shut out of having a voice in any kind of government. Somebody died so I could go to LSU. My father worked by the sweat of his brow to pay for me to graduate from college debt-free. And I did the very best that I could in studying and doing what I could to get into law school. I was one of 8 African-American graduates from Louisiana State University Law School. That's not Sharon. That's because God gave me a gift and I chose to use it in service. And I am very proud of the service that I've been able to render. I've had cases that I have taken from district court to the Supreme Court level and been successful. I've received cases from the public defender's office that both of these gentlemen have handled and been able to get dismissals for clients. Not that they've done anything wrong, it's just the clients ended up having a family member to gift them with the resources to pay me to work hard. I am proud of everything that I've done. I am proud that I understand what it means to serve. And I promise you, I will not make you ashamed. I will advance the direction of this court. All 3 of us have practiced in that court. Judge Carter, I'm proud to have his endorsement. And it is not because he's ashamed of these 2 gentlemen. He knows that I possess the courage and the strength to take this court to the heights that it needs to go. And I will be honored to have your vote and serve as your judge. Thank you.
Thank you. Mr. Key.
I think there's ancillary problems that create the issue of why there's not a lot of black folks on the jury sometimes. One of the reasons is because they have a felony conviction, not able to do some jury duty, and there had to be prosecutors who convicted them. I want to say this. I have good friends who are prosecutors. I have good friends who are defense lawyers. I would never suggest, and didn't try to suggest, that Ms. Wilson abused or wronged anyone. What I would suggest is that if she only handled murder and rape cases, we wouldn't be talking about this at all. So we need to talk about over 17 years that she only handled rape and murder cases. We need to talk about the 95% conviction ratio that she touts in her contribution letter. Contribution letter says, hey, 95% trial success ratio. Well, that's sending people to jail. When they go to jail and become felons, then they can't serve on those juries. So then who we have to pick? People who know nothing about the people who come before them. That's what we must go against. Can't allow that to continue to happen. We have to rehabilitate those who we can so they can have the ability to vote. to work, to be on jury, get TWIC cards and things like that that are important. She talked about Judge Carter's endorsement. Let me talk about that for a minute. I think that's a strong endorsement. Judge Carter's a great guy. At the end of the day, Judge Carter decided on his own volition to step off of the bench. He could have stayed. We don't need a continuum of the past. We go to status quo. We need a continuum of the future. And we need to grab those things that were important, those things that moved our community forward. Use those things, but then go into a new way of being progressive thinking and building our own name on our own merits.
Thank you. Mrs. Wilson? To repeat the question. Oftentimes, the jury pool in Calcasieu Parish does not include a lot of minorities. Do you think this affects the outcome of certain types of cases? And if so, please give a few examples.
Okay, I've tried over 100 jury trials, and most of the cases that I've had have had very good minority representation. It's the lawyers who pick a jury. And it is up to the judge to make sure that lawyers are not eliminating jurors simply based on race. The United States Supreme Court case of Batson, and that's what lawyers raise, is a Batson challenge. The judge decides whether or not that Batson challenge is valid. When a lawyer raises a Batson challenge, what he's saying is this particular prosecutor is eliminating jurors because of race or some other constitutionally prohibited reason. The judge makes the final call as to whether or not that's true. That's why it's very important that you have a minority judge, because we as Black people know that racism is covert. It is not overt. And there are times when challenges are being raised by prosecutors that when you haven't been one, you might not know that that's a trick of the trade, that they're actually saying this is a race-neutral reason, and it's not. I'm gonna call it. If I see it, I'm gonna call it, and I'm going to say, tell them it's a Batson violation, and we're gonna have minorities served. Minorities show up every day at the courthouse for jury duty. They don't always make the final cut, and it's because the lawyers pick the jurors, but the judge has the final say as to whether or not that's a valid challenge.
Thank you. Mr. Ned?
I think jury compositions, I think that was the question about jury composition, minority representation.
Do you think it affects the outcome of certain types of cases? And if so, give some examples.
Certainly, it could possibly affect the outcome of a jury trial. I think minority representation is lacking in a jury composition. Of course, it's up to the attorneys to select a jury during voir dire and to try to weed out any prejudicial racism that may exist. It's important that we feel and see with a judge who can see things for what it is and call things for what it is. The judge makes the decision of whether or not a juror is excused based on whatever challenge of an attorney. I think that all citizens should be assigned the same quality of justice. And we gotta look at people not for their color, but for the content of their character. And that's what's important in selecting a jury. But I do think that there's a need for more minority representation on a jury. Thank you.
Thank you. Mrs. Wilson, why do you think you are better suited to replace Judge Carter as the next judge at the 14th Judicial District Court than your counterparts? And if you were not in the race, which one of your counterparts would you vote for and why?
I think that I'm better suited for this job because I think it takes a balanced approach to handling cases. I think that you have to have an even temperament. You also need to have experience. And I've said this before, I have experience on both sides of the ball. And I understand how a call plays. I've just experienced it. And experience is so important. It is so important. And the reason that that experience is important is because you don't know what you don't know until you've experienced it. You can be as smart as you want to be and as gifted intellectually as you want to be, but unless you've actually been in those trenches and seen it, you can't have on-the-job training in this job. And that's what sets me apart from my opponents. The last part is because I value experience so much, if I were not in this race, I would have to vote for Mr. Ned.
Thank you. Mr. Ned, why do you think you are better suited to replace Judge Carter as the next judge at the 14th Judicial District Court than your counterparts? And if you were not in the race, which one of your counterparts would you vote for, and why?
I believe it's my compassion, my strong work ethic, I think my life has been filled with both personal and professional challenges that have given me a broad perspective on life. That in my involvement in community, which gives me the qualifications to be judge. As far as what opponent I would determine to serve in Division FC, I'll have to defer that question because I have a great deal of respect for both of my colleagues. And I think that anyone that enters the public arena, you have to applaud. Mr. Key is a fine man, Christian man, humble man, smart man. Ms. Sharon is very smart, very capable, Christian woman. So I will not defer that question. I'll give our respect to my colleagues.
Thank you. Mr. Key?
We've had to run down on experience, and I think I should just point out, neither one of us has served one day as a judge. Okay, so whoever goes in, it's gonna be their first day as a judge. They're gonna learn how to be the appropriate judge, and we're gonna get to see whether or not they're making the decisions that they're saying they're gonna make here at the table today. I think my decisions are gonna be made the same way they've always been made, in the interest of people, in the interest of the community, in the interest of what is right, what is fair, what is just, and an opportunity to have parity across the board in all types of cases. I think that's what sets me apart. My experience is not the experience that suggests anything other than what I'm saying. You have to look at everybody and make your determination of what somebody's saying versus what's really true. I'll say to you that I have experience in the court of law, but the court of life also gives you experience. That's why I'm able to walk down the streets where my clients are. I don't deal with them like they're lesser than me or like they can't come up to me and speak with me. That's why we talk in our churches, we talk in our supermarkets, in the stores. We talked at the park when I was out there yesterday because I don't set myself at a place where people don't feel comfortable coming to talk to me. If given the opportunity to vote, I'm very sure who I'll vote for. If I had an opportunity to vote for someone other than me, I vote for you, the people of this community. I look at these people, these two candidates, and I make a determination at that point. I'd be honest with you, the reason why I got involved in this election initially because there were so many people said, I'm not satisfied that I have my choice. Give me a good choice. So I decided to be that good choice, and then if I'm not the choice, then I'll make a decision based on each of you and what I think is good for our community. Thank you.
Thank you. And now I'll proceed to the audience submitted questions. This one in particular drew my attention, so I'll start with this one. Whitney Houston said it best when she sang the words, "I believe the children are our future." The unfortunate reality is that by the age of 20 or 21, many of them already have a criminal record. When elected judge, how do you plan to help our young and sometimes illiterate people so they are not repeat offenders? And Mrs. Wilson, what are your plans for reform.
What you hope is that they have good legal representation that's actually worked something out for them prior to this coming before you. What you'd hope is that the lawyer that's representing them has worked something out so it doesn't even get to court to prevent them from having a criminal record. Once it's in front of you as a judge, that means this person is actually entering a guilty plea. And as a judge, you're not an advocate for either side. You're an advocate for the citizens and doing what's best for society and for that person that's come to court. What I would hope is with guilty pleas, that every time an 893 is available, and that just means a deferred imposition of sentencing to give a person a path to cleaning up their record, I plan on implementing that. If they are standing accused, I plan on trying to use certain pretrial programs to prevent them from having to actually serve time in jail while they're awaiting court. I do plan on being involved in drug court and mental health court because someone going into those courts means that they will not have a conviction. It also means that they're not going to lose their public housing, which is very, very important. Once you have that conviction, you're not going to get government subsidized housing, especially of violent offenses. So those are the things that I can do as a judge and plan on doing and plan on being a voice and getting involved in.
Thank you, Mr. Ned.
We're facing a high rate of juvenile incarceration. I was a juvenile attorney for quite some time, and I saw repeat offenders coming back from car theft and burglary to rape and murder. I handle those type of cases, and the opportunity to look into these kids' eyes and try to make some sense of what makes them tick. The problem, I think, is economics, education, and rehabilitation. Economics, the lack of employment opportunity for minorities. Education, we're facing a high dropout rate. We have more kids selling drugs than ever. And I think rehabilitation measures. I think the penitentiaries should encompass some type of rehabilitation measures, not just having rehabilitation centers. I think the jail should encompass this for the fact that while inmates are sitting, they have a chance to get substance abuse treatment, life skills courses, in order to make them adapt to society. You know, if I had clients receive 5-year sentences, 6-year sentences, they had no rehabilitation whatsoever. It makes no sense to me. So they come back on the streets more violent than ever. Our kids are our future. And from the beginning, I said, this election is not about any other candidate. It's about our children, our community, and our future. I think I'll be a catalyst for advancement of rehabilitation measures. I would recommend rehabilitation whenever possible, pretrial programs to help our children adapt better to society. The mic. But in my opinion, economics, education, and rehabilitation is the key to reform. Thanks.
Okay, Mike. Okay? Yeah.
The duty of the judge, you laid it out in the beginning when you were talking about Judge Clark, is to be visible before somebody gets to the criminal justice system, to your courtroom. When I go to my children's school, when I go to their daycares, when I go to the parks, the kids run up to me and say, "I'm voting for you." Kids who are 3, 5, 7, 9. That moves me because that means they're engaging in something positive at a very early stage. We have to be mentors. We all have done some mentoring. I've mentored at several schools. I've sat on panels to move black males together, and I've been in numerous churches speaking, particularly to their males and to their youth, men and women alike. You have to be engaged before they get to the system. And once they get to the criminal justice system and before you, it starts from the very point that they have a bond. If you allow someone to go to work who's a nonviolent offender, then you're not paying for that family who's not gonna need housing, not gonna need welfare, not gonna be paying taxpayer money to keep somebody in jail and do 3 hots in a cot. That's not what we're in here for. What we're in here is to help from the very beginning. So if I release someone on my free to work program, you know what that does? That puts them in a position to stay where they're working, pending trial. Puts them in a position to pay their bills, pay their child support, take care of their family. Support their family like we should. So as a judge, everything we do, and last point is through sentencing. Everything we do affects the children. If we're sentencing folks who have 2 or 3 pills or have a drug problem, we haven't dealt with the issues of what's going on with them, mental health wise and substance abuse and rehabilitation wise, then we can't, in good faith, say, hey, we expect things to have a good effect on the children, because those children without dads and moms at home don't do better. So that's what I would do as a judge, make sure that we help them in every stage and stand between the domino effect that tries to put our children at risk.
Okay. Mr. Ned, it always appeared that Judge Carter's cultural identity, background, and values weighed heavily in his afforded judicial discretion while on the bench. He took pride in his employment of an all African-American staff. His fairness of law interpretation for all that came before his bench as he based his decisions on his ethic values, knowledge of the law, and his judicial philosophy. Will your cultural identity have any influence in your decisions as a judge?
I have to say most certainly. From my background, if you look at my background, my great-grandfather was Sam Sides, first black sheriff in Calcasieu Parish. He was a sheriff when blacks could not arrest whites. He would have to call for backup. I had another grandfather who was a maitre d' at the Pioneer Club. He used to serve judges, the white judges. My dad shined shoes at Grimm's Barbershop, one of the first black barbershops here, while his brother cut hair, was a barber there. So I have some pretty positive influences out there, ethnic-wise, that I can continue the tradition, our cultural tradition. Being a judge is, you take an oath to follow the law, but it's not just applying the law. It's about people and dealing with people and life experiences and common sense and compassion and courtesy. So as an African-American judge, hopefully be elected the second African-American judge in Calcasieu Parish, I think it's very important that identity remains intact. Thank you.
Thank you. Mr. Keith?
Commonality of ideas and ideals are very important. It's important that we have folks around us who understand where we're from, and what we do, what happens in our neighborhood, what happens in our churches, what happens in our houses, in our community. Certainly, there should be no reason why we shouldn't always aspire to hire blacks into all of these positions. Why would you say we should have a black judge, but we shouldn't have anybody black to do the stenography or to be the secretary? I think that it's important for us to get people who are going to work with us, who has the camaraderie and the same similarity of mindset. Similarity of mindset that would suggest that you should be helping folks in the community, that you should have an urgency when it comes to folks calling saying that their kid's going to lose their job. I will have people around me who are like-minded, and certainly there will be black people around me. Thanks.
Thank you. Okay. Mrs. Wilson, as judge, would you be willing to strike down laws you felt were unconstitutional? And how much research and time would you be willing to commit to writing opinions that are less likely to be overturned?
question is yes. That's your job as a judge. I mean, you are duty bound to follow the law. And the answer to a question that was posed earlier is the reason we have higher courts is because judges don't always follow the law. And that's why I have disagreed with judges' opinions when they didn't follow the law and taken cases to higher courts. That's why we all do it, because judges don't do what they're duty bound to do. The case, if something comes before me that's unconstitutional, yes, I'm going to declare it unconstitutional. That means it immediately goes to the Supreme Court, and I know where it's going. I'm going to document it. I'm going to say why it's unconstitutional. But I'm going to call it like I see it. Don't have a problem doing that. And I didn't get the last question, but I'll go ahead and answer it. And the answer to that is I'm never going to forget where I came from. Okay? I think that I said it already. This society needs diversity. It needs a voice from everyone, every gender, every race.
That will conclude our line of questioning officially. I would like to thank you all for coming. We will have a brief refreshment period throughout which, if the candidates are willing, you all may ask any questions that were unasked by myself that you feel you really need to have answered. Whatever time you guys have available, we would appreciate if you could stick around, meet with the audience, answer any further questions. But for the sake of your schedules, we're going to begin to wrap this up. And on behalf of the Most Worshipful Prince Howard Grand Lodge of Louisiana, Dr. A. Ralph Slaughter presiding as the Grand Master, and on behalf of the 7th Masonic District, where the Honorable Sharon Papillon presides as our District Deputy Grand Master, I once again would like to thank you all for coming out. I hope this was enlightening to all of us. And please, if you have the time, stick around for the refreshment period. I'm sure our candidates will be more than happy to help you with any further questions you may have. If there's anything else you need before we proceed to leave, the brothers in the suits can help you with anything you might need. Thank you.